Hello again, it's Professor Harper in Journalism and the Law. And I'm going to do a short lecture on cable television, which is treated differently than digital television or what's known as over the airwaves television, even though we don't get it that way very often anymore. So cable television, a bit of history. In the mid-1950s, it was called Community Antenna Television, or CATV. And essentially what it was is there were a number of areas where it was difficult to get over the airwaves television because communities were surrounded by mountains or the broadcast signal couldn't get there easily. And initially the FCC refused to regulate cable despite pressure from traditional broadcasters. But then in 1962 the FCC determined that it would regulate cable because it involved interstate communication by wire. The channels are made available to public government officials and school administrators in the initial regulation, and that the cable operators also had to provide equipment for those who wanted access. But in fact, in the U.S. Supreme Court determined that the FCC had exceeded its authority in forcing the cable operators to do this in a case, the FCC versus Midwest Video Corp. The cable television system operates significantly different from the major networks, so that unlike standard broadcasting, cable operators sign individual franchise agreements with cities and towns. So it creates a virtual monopoly in those cities and towns. There's no real competition except from satellite television with the cable operator. In 1984, the U.S. Supreme Court found that the FCC and not localities, however, had the power to regulate cable. That was a case called Capital Cities Cable versus CRISP. In 1984, the Cable Communications Policy Act deregulated cable and allowed expansion. The cable operators were able to determine the prices that were charged to the consumers, and it also limited the fees that the local franchising authorities could charge to the cable companies. 1992, the Cable Television Consumer Protection and Competition Act rolled back some of the provisions of the 1984 law. So it actually regulated the rates the cable companies could charge. And it also forced the cable operators into what are called must carry. That it forced the cable to carry local broadcasts or retransmission consent, and that there were certain things that the FCC forced the cable operators to do. In 1996, the Telecommunications Act, which I applied to over the airwaves broadcasters as well, it focused on increased competition and allowed telephone companies and cable companies to enter each other's businesses. And as a result, a lot of mergers came about. So for example, you now have Comcast and NBC. And in terms of cable television and the First Amendment, it's kind of a mixed bag. It's neither a newspaper nor an over-the-airwaves broadcast, and I apologize for using over-the-airwaves, but that's really the legal definition of ABC, CBS, NBC, CNN, etc. In 1986, the Supreme Court found that in Los Angeles v. Preferred Communications that cable operators engage in aspects of speech that are similar to newspapers and book publishers. So it was actually seen more as print than it was as television. And in 1991, in a subsequent case, Leathers v. Medlock, that cable engaged in speech under the First Amendment. 1994, Turner Broadcasting System versus the FCC. The U.S. Supreme Court held that the First Amendment applied to cable in two ways. First, government regulation of content was difficult, and the government has the burden of proof, or what's called the so-called strict scrutiny test. And government regulation of material other than content is much easier in terms of, the government can regulate the structure of the rules that govern cable. But in the case, the U.S. Supreme Court found that although a daily newspaper and a cable operator both may enjoy monopoly status in a given locale, the cable operator exercises far greater control because it can exclude voices that are, shall we say, unpopular. You also probably know that cable television can show pornography, whereas over the airwaves broadcast cannot. Again, I'm not going to go into a great deal about obscenity and indecent material, but those are the specific terms that apply when it comes to sex, nudity, etc. There's something called non-content regulation, in which the local franchise authorities regulate pricing on a local basis and tier, and these include the local broadcast outlets, the public access channels, and the cable operators can set rates for the cable tier on the basic things that are usually in the basic package, such as CNN, MTV, TBS, ESPN, and then the premium channels, HBO, Cinemax, and pay-per-view, are not regulated in terms of what can be charged. In terms of cable ownership, broadcast television was prevented from owning cable in what's called the cross-ownership rule in 1970, but in 2002, the U.S. Court of Appeals in the District of Columbia eliminated that ban. Attempts to limit cable operators' ownership failed, and so Comcast, Time Warner, Charter, and Cox control about 60% of all the cable outlets throughout the United States. As I said, there are these must-carry rules, and they're still in existence, so it's really to protect the strength of local broadcasting. It also ensures viewers to have access to local news, and it does promote competition for delivery of video programs. At the beginning, there were public education and government channels as part of cable. They were not required but permitted. And in 1979, it was determined in the Supreme Court in FCC v. Midwest Video that the cable operators actually had control over these so-called PEG channels. And in terms of free speech, it runs in some odd ways. So the Missouri Knights of the Ku Klux Klan versus Kansas City, the federal district court found that the city had restricted the Ku Klux Klan's free speech by ending the PEG agreement and forced the cable operator to and the city to actually allow the Ku Klux Klan access to the public channel. Cable and the internet, broadband availability on cable provided easy and high-speed access. The FCC classified cable access to the internet as information rather than telecommunications or cable service, so it set it as a separate entity but still regulated by the FCC. The Supreme Court upheld the definition that the FCC had promulgated in National Cable v. Brand X Internet Service, and it also protected the cable companies from providing access to their lines. So that's a brief overview of cable television. Significantly different from over the airwaves or digital television in the traditional sense of ABC, CBS, NBC, CNN, etc. It seems odd, but that's simply the way it is in terms of the way that cable television comes to us today. So thanks very much for listening, and we'll see you online.